Good morning, everybody. Looks like we're all present and ready to go. So we'll go ahead and reconvene our meeting that we started yesterday. If I can get Ms. Taylor to please call the roll.
Certainly. Chairman Vasquez.
Present.
Vice Chair Schaefer.
Present.
Member Gaines.
Present.
Member Cohen.
Present.
Deputy Controller Stowers.
Present.
So we have a quorum. Everybody's present. Want to just once again remind everybody, another friendly reminder that we're all sharing the same line. And I know some of us yesterday, and it looks like today again, are experiencing some technical problems with the internet. So if I could just remind everybody that, and you did a great job yesterday, hopefully we do it again today, in terms of just identifying yourself, and I will recognize you to speak so we can make sure the transcription gets it right when they're recording our minutes, and keep everything as clean, as clear as possible. With that, let me have Ms. Taylor please announce our first order of business.
Our first order of business is an announcement regarding the public teleconference participation. Good morning, and thank you for joining today's Board of Equalization meeting via teleconference. Throughout the duration of today's meeting, you will primarily be in a listen-only mode. As you may know from our public agenda notice and our website, we have requested that individuals who wish to make a public comment fill out a public comment submission form found on our additional information webpage in advance of today's meeting, or alternatively participate in today's meeting by providing your public comment live. After the presentation of an item has concluded, we will begin by identifying any public comment requests that have been received by our board proceeding staff, with the AT&T operator providing directions for you to identify yourself. After all known public commenters have been called, the operator will also provide public comment instructions to individuals participating via teleconference. Accordingly, if you intend to make a public comment today, we recommend dialing into the meeting on the teleconference line, as the audio broadcast on our website experiences a 1 to 3 minute delay. When giving a public comment, please limit your remarks to 3 minutes. We ask that everyone who is not intending to make a public comment, please mute their line or minimize background noise. If there are technical difficulties when we are in the public comment portion of our meeting, we will do our best to read submitted comments into the record at appropriate times. Thank you for your patience and understanding.
Thank you. Before we begin, members, I just want to thank Senator Hertzberg, Robert Hertzberg, and then my Senator Ben Allen, and then one of the co-authors now, Senator Mike McGuire, for their work to introduce SB 539, which would implement the constitutional provisions of Prop 19. Members, due to the introduction of this important Proposition 19 legislation just a few days ago, I would like us to start with that, as it really drives everything else that we will have on our agenda today. Therefore, I'm going to move item M from our public policy hearing on Prop 19 up to the first place on our agenda to give time to our Executive Director, Ms. Fleming, and her staff to provide an overview that was scheduled under K4B legislation by Ms. Fleming. This will allow each member, the assessors, and the public to hear her report as questions as we provide input moving forward. Having said that, since there is our Prop 19 items and discussion matters on the agenda, we will need to limit the public policy hearing session to 1 hour in order to give all other scheduled speakers an opportunity to present their reports and to answer questions. This means that after we conclude item M, the Prop 19 public policy hearing, our second item will be item G, rulemaking. Our third item will be the K1D, an overview of the action plan for Prop 19, which has 6 sub-items. And then our fourth item will be item K4B, legislation and recommended board action by Ms. Fleming. With that, and then just a big shout out and a real thank you to staff, the BOE staff, and my chief of staff and my staff. You know, these last 2 weeks, I know it's been real tough, and I've asked them to put extra hours in, especially over the weekends, to make sure that we got this thing moving. And with the help of our senators and the leadership, we now have a bill that we could move forward. Now the task is going to make sure that it gets through these committees and moves forward in a productive way. And of course, we had a lot of participation from our assessors leadership, you know, Mr. Ernest Dronberg and then Jeff Prang, my assessor here. But with that, let me open it up and see if any of the members have any opening remarks before I ask Mrs. Fleming to begin our presentation on item M. Seeing no hands, we will go ahead and get started then. Ms. Taylor, is Ms. Fleming on track and available?
I believe she is. Would you like me to call the first item?
Yes, please.
Our first item is M, public policy hearings. Items that appear under these matters provide information to the members and may require board action or direction. Sub-item 1 is Proposition 19 implementation. Discussion on the implementation of Proposition 19, the Home Protection for Seniors, Severely Disabled Families, and Victims of Wildfire or Natural Disasters Act of 2020. Is Ms. Fleming ready to present?
Good morning. Thank you, Ms. Taylor. Good morning, Chairman Vasquez and honorable members. This is Brenda Fleming, Executive Director. Happy Wednesday. Members, I will provide an overview of the proposed legislation related to the implementation of Prop 19. As I recently informed the board, last Thursday, February 18th, Senate Bill 539 was introduced by Senator Bob Hertzberg, joined by principal co-authors Senators Ben Allen and Mike McGuire, to assist in the implementation of Proposition 19. The bill's member adds Section 63.2 and 69.6 to the Revenue and Taxation Code, which provides clarifications related to intergenerational transfers of real property and base year value transfers. The crucial elements in the introduced bill will include defining the eligibility requirements, such as transfers can be from grandchild to grandparent, excludes step-parents from having to be deceased for grandparent, grandchild, and property must be maintained as a family home, and some additional filing requirements. Members, Mr. Moon is going to go into a great deal more detail when we get to the G item as a part of the rulemaking process. And we'll talk more about the details of the legislation, the rulemaking process, and the two options that we have with regular rulemaking process and then the emergency rulemaking process. We'll talk a little bit more about the agility that the emergency rulemaking process provides. We've exercised it before, but just noting that if with that ability to do emergency rulemaking process, the emergency rules, as you know, is just temporary. I'm pleased to share that the bill also includes the authority for BOE to adopt emergency regulations and produce forms and instructions in order to implement Prop 19. But again, I'll note the bill has just been introduced and is not yet enacted. Members, I will provide a brief overview of the legislative process. Normally, bills are required to be in print for about 30 days before they are heard or acted upon. The Senate has recently taken action that allows the bill to be heard earlier than 30 days. As of today, it is anticipated that the bill may be heard in the near future, in the next week or so possibly, by some of the policy committees. We're hearing it possibly could be Senate Gov and Finance, but again, that's tentative and we'll wait for the legislature to publish their information. During the committee process, members, the bill may be amended, and that will be another opportunity at the public legislative committee hearing. That will be another opportunity for the public and all of us to provide additional public comment and engage in public discussion. Members, also, the California Assessors Association's legislative and their executive committee met yesterday regarding Senate Bill 539. The purpose of that meeting was to discuss the legislation as it is compared to the full legislative proposal that was attached to our January PAN. There was agreement between our organizations, between BOE and CAA, to recommend a letter of support for Senate Bill 539. And we'll talk about that under a later agenda item today. I'll be asking for your approval to proceed with a letter of support. Members, as I noted before, bill introduction is the first phase of the legislative process. As you can tell, over the last few weeks since we've been meeting on this, things are moving quickly and they change from morning to afternoon. So it's a rapid, very exciting process. Later in today's agenda, members, I will ask for the board's approval, as I mentioned, to submit a letter of support to the legislature and can take any questions for you at that time. This concludes, members, my high-level overview for this portion of the public policy discussion. And we have an opportunity now to have more discussion or Q&A, and also if there's any public commenters. Thank you, members.
Thank you. Any questions from Ms. Fleming? I have one quick one. Ms. Fleming, I know now that this newly introduced legislation, SB 539, the Hertzberg bill, is out there. Where can the public find this bill? Is it posted on our BOE website yet?
So there's two areas, if you can hear me, two areas where the information is available. So one, we will have the link to the bill information on our BOE.ca.gov website. It's also available if you go to the legislative website, either through the Assembly or the Senate. But again, the link is also available on our website. So we encourage anyone to visit the website for additional information.
Thank you. Any other questions from any of the members? If not, let me ask if there's any questions, or are there any assessors on the line that have any questions or comments on this? Ms. Taylor?
I think if we open the line, yes.
I just saw a hand up go by Member Gaines. Member Gaines, go ahead.
Great. Thank you. How are you, Tony?
Good, good. How's it going?
Good. Yeah, thanks for the opportunity, Chair Vasquez. So I just wanted to clarify. I know that there have been some issues with agriculture in terms of trying to provide some clarity, and it's my understanding that that will be addressed at a future time. And so I just wanted to acknowledge that there are some challenges in terms of the interpretation, potential challenges, and we just want to make sure that they're clarified and that there'll be a vehicle in the future to address those. I've got a lot of agriculture in my district, and there's just a lot of concern. I think the ag community felt that it was addressed in the original language in the initiative, but we just want to make sure that that remains clear, and that family farms have that opportunity to pass land on to the next generation. And of course, you have some challenges when it comes to valuation of property versus the actual revenue raised off the property. And I think cattle ranching is probably one of the best examples where low margin business, but you could have high valued land that could break up a family farm or ranch that's been in operation for generations. So just wanted to bring that issue up and encourage that we're going to have an opportunity to address that as earlier discussed. So thank you, Chair Vasquez.
No, thank you. That is a good point. I mean, they're calling it the skinny bill, but this bill that's actually moving forward now doesn't have everything. You know, I mean, we had a whole laundry list of things, but the legislators were saying, well, if you want to fast track it, give us what you need now. And that's what you see here in 539. But we still have hopefully another bite at the apple coming soon before the April 1st deadline. And we'll keep you posted on that as that moves forward. And I see a hand also from our president from the assessors, Mr. Ernie Dronenberg, if he's available, if we can get him on.
Good morning.
Good morning.
It's good to see you guys. I think Ted's mouth's moving. Was he trying to say something? But
no, I think we're good. Go ahead.
I can't overstate the amount of teamwork that has gone on this. And I've been around a long time, and I've never seen such cooperation, such overtime, working weekends, hours plus, by the Board of Equalization with the assessors on an issue. It's really heartbreaking to think about what the past could have been if we had this kind of cooperation. It's really cool. And special kudos to Brenda, because every other word out of her mouth was during this process is, we need emergency regulations for the board. We need emergency regulations for the board. She didn't care if anything else was in the bill, as long as it included emergency regulations for the board. And they're there. So that's really important. You guys are going to fill the gap of what the legislature is going to allow us to have. And I feel like this is all old hat to Ted. He spent many years in there. He knows what we see is not necessarily what we're going to get, but the author of the bill, and it's co-authored by McGuire, and that's really good because he's really sticking up for the farm interest, Ted. he's there in spades for the farm interest. But the author of the bill has said, and I don't want to say too much because Moon's going to do an excellent presentation, I'm sure. But he has said that there will be no amendments to this bill because he wants to get it through. And the way to get it through is take no amendments. Of course, I know here again, Ted is really grinning because he knows that there's no such thing as no amendments. If somebody really wants it and it's do or die, it'll be amended. But that's what he claims. And so I'm not going to talk about substance. You've got Moon, who's been really involved with this, and he's done an excellent job. I'll let him get into the details in the budget, but just compliments to your staff and letting you know what we see as the progress. And we're spending all of our efforts with our lobbyists on this thing, and it's been quite a lift.
Thank you. I see another hand now from Ms. Stowers. Go ahead, Ms. Stowers.
Thank you, Chair Vasquez. I also wanted to say how grateful I am that SB 539 was introduced. I am so looking forward to it being moving forward and enacted. I'm going to wait for Mr. Moon's presentation to clarify some of the rulemaking, but I do want to acknowledge the work that BOE staff did. It was a heavy lift, you guys, and you guys stayed focused and continued to push. Same thing with the assessors, their staff and their lobbyists and their push for it. And of course, the member staff who had some involvement and others who you may or may not know about. So it was all hands on deck to get this bill introduced. So hopefully we don't have any amendments so we can keep it moving forward. And anything that's lacking in the bill, as long as we can clarify it in the rulemaking process, I'm all aboard. Just looking forward to moving it forward. Thank you.
Thank you. No, you're right. Both of you spoke to this. You know, there was just so many folks that spent the extra hours and extra time on this, and I really appreciated it. But with that, let me just check and see if there's any public comments. Ms. Taylor, are there any public comments on the content of SB 539?
I will check. AT&T moderator, can you please let us know if there is anyone on the line who would like to make a public comment regarding this matter? All callers are requested to limit their comments to 3 minutes in order to provide everyone with an opportunity. For the record, we request that callers provide their name.
Thank you. If you wish to make a comment, please press 1 and then 0 at this time. And I do have one in queue. It'll just be 1 moment for their name.
Their name. Yes.
Thank you, and we'll go to the line of Joseph. Please state your name followed by your comment.
Joseph Panino. I want to thank Chairman Vasquez and all the other honorable chair people. I'm not sure if this exactly falls into Senate Bill 539. However, my concern is the implementation of Prop 19 and the gray area from the point that it was approved in the election to the point we get the application and the interpretation for the administrative process. That's a pretty big area there, and I happen to fall within that area of selling a primary and then picking up a replacement property. So I was wondering, am I off base here? Do I look in 539, which may pick up my concerns, or is there somebody that can comment on that and lead me in the right direction? Thank you.
Thank you. Is there anybody else on the line, Ms. Taylor, or was that it?
I have no further comments in queue at this time.
What I would just suggest for that last caller, just keep checking our website, because we're trying to keep it as current as possible, especially as SB 539 moves forward. And if for some reason this doesn't answer your question, by all means, on our website, you can reach out to our staff, either our staff up in Sacramento, or depending on what district you're in, you could locate any one of the members as well. But feel free to reach out. At the end of the day, I always suggest and recommend, because we're not legally in a position to give you legal advice, I recommend that you check with your, whether you're working with an attorney or your real estate people or your financial folks, because every case is very specific and very unique. And I don't want to misguide anybody or lead somebody on with misinformation. So for me, I think I think the safest thing is to check the website, and if you don't find an answer there, then I would continue with either one of our staff, our district offices, or our staff in Sacramento. And if that doesn't clear it up for you, then I would refer back to whoever you're working with that's doing your financial planning, just to be safe, especially on real estate. I see a hand up by Vice Chair Schaefer.
Yes, Chair Vasquez, I just wanted to say I have no special comments, but I am so impressed with Assessor Dronenberg's presentation, showing how hard his staff and our staff have gone the extra mile to make this all possible. And we need more input from him. Thank you.
Thank you. No, this has been really a real team effort. And I know Mr. Dronenberg and some of his other assessors went that extra mile, and I really appreciated the time and effort they put in as well to work with us on this. With that, if I'm not looking and seeing any other hands or comments, Ms. Taylor, would you please call our second agenda item?
Yes, our second agenda item is G1, Chief Counsel Matters Rulemaking. Overview of the plan to develop guidance and rulemaking, presented by Mr. Moon.
Thank you. Mr. Moon, are you available at this time? Oh, I see you now on the screen. Okay.
I am. Good morning, Chairman Vasquez, members of the board. Richard Moon with the legal department. As you know, staff's been working on various types of guidance for Prop 19, and we most recently published an LTA 2021/08, which includes about 40 questions and answers regarding the intergenerational transfer exclusion. And this LTA gives assessors, taxpayers, and interested parties guidance on topics such as, for example, timing, valuation, specific transactions, and partial transfers. And we believe this LTA does provide significant guidance. However, as you're aware, guidance published in the form of an LTA does not have the authority that regulations do. Therefore, in addition to the LTA guidance, we've been working on draft regulations, 2 new regulations, and amendments to several existing regulations. Because work has also been proceeding along the legislative track, staff has been preparing to move the rules through either the emergency rulemaking or the regular rulemaking process. And as you know, and as has just been discussed, SB 539 has now been introduced, and it includes explicit emergency rulemaking authorization, but it has not yet passed, and it is not clear how quickly the bill will move. Therefore, instead of waiting, staff will begin the regular rulemaking process following the procedures required by OAL and the APA, and adhering to our usual practice. If SB 539 passes during this process, staff would bring the rules to the board for adoption as an emergency regulation and also continue with the regular rulemaking process. We would then go down both tracks simultaneously, effectively pulling forward the regular rulemaking that would ordinarily follow the emergency rulemaking process that makes the emergency rules permanent. As stated, we're drafting two separate new rules, one covering the intergenerational transfer exclusion and one covering the base year value transfers. And we're a little bit further along on the intergenerational transfer exclusion rule because of the earlier operative date. So for the intergenerational transfer exclusion, as you know, Prop 19 excludes transfers of a principal residence between parent or grandparent and child or grandchildren that continue to use the real property as their principal residence. The regulation that we're drafting contains specific guidance regarding definitions or what you may characterize as substantive parts of Prop 19 regarding filing and regarding valuation. With regard to the substantive definitional category, some of the issues that are addressed in the regulation are the continual residence requirement in the real property as the principal residence of the eligible transferee, that the allowance of transfers from grandchildren to grandparents so that the transfers can go both directions. The rules also state that eligible transferees have 1 year to establish the real property as the principal residence, and also that a family farm need not include a principal residence. And these requirements that are in the regulation or in the draft regulation also mirror what is in SB 539. Things that are in the rule that are not explicitly in SB 539, but that the rule clarifies, include items such as that only a single eligible transferee need make the real property their principal residence. It has claim filing requirements, and although SB 539 does not specify what those requirements are, it does require the board to come up with claim filing requirements, and so these rules would do that. The rules also address the fact that assessors can ask for verification for the exclusion or for the continued residence, that the transferor cannot also transfer the base year value to another principal residence, and it also has a portion dealing with the application of supplemental assessments. As far as the filing requirements, the rules would state that a claim must be filed within 3 years or within 6 months of supplemental assessment or prior to the transfer to a third party, or else there will only be prospective relief, and again, as long as the property hasn't been transferred to a third party. And these filing requirements are not explicitly stated in SB 539, but they do mirror what currently exists to file a claim under Section 63.1, which is the parent-child exclusion under Prop 58. As far as valuation, the rules will demonstrate the calculation of how the new taxable value is calculated upon application of the exclusion and upon removal of the exclusion, and it will be described and then fleshed out with a number of examples. And again, that level of specificity is not in SB 539. For the base year value transfer, again, as you know, Prop 19 allows transfer of a base year value from an original principal residence to a replacement principal residence for those 55 or over, severely disabled, and victims of wildfire and natural disasters. Here, again, the regulations contain specific guidance around substantive or definitional requirements, filing requirements, and then valuation. So examples of items that are in the substantive or definitional category would include that either the sale of the original residence or the purchase of the replacement residence, but not both, may occur before April 1, that each spouse gets 3 transfers and a previous transfer that may have been made under 69.5, the old base year value rules, will not count towards those 3 transfers. And those items are currently in SB 539. Things that are not in SB 539 that the rule clarifies would be things such as specifically or explicitly including victims of wildfire and natural disasters. That is not explicitly stated in SB 539. It would explicitly include a filing requirement. It would explicitly include a number of definitions, and it would explicitly include that a claim for 69.5 is not a public document. That requirement is there in the intergenerational transfer exclusion in SB 539, but not in the base year value transfer portion. As far as filing requirements, the rules require that a claim must be filed generally within 3 years of purchase or completion of new construction of the replacement principal residence. That is not in 539, SB 539, but it does mirror the current requirements that are in section 69.5. With respect to valuation, the rules will establish the dates on which valuation are to be established, and then examples of how the calculation of the value is to be done. And again, that level of specificity is not in SB 539. As far as our process and our timing, again, we have 2 brand new rules that will be created. We expect that the first new rule, the one covering the intergenerational transfer exclusion, will be published for comment early next week. And the second, regarding base year value transfers, 1 to 2 weeks following that. Each rule would then move along similar but separate tracks, separated by about a month time, and that will allow staff to focus on completing the intergenerational transfer exclusion rule first, and then complete the base year transfer rule. And again, that's because of the earlier operative date of the intergenerational transfer exclusion. The process for both rules will involve staff bringing them back to the board 2 times. The first would be for approval to send to the Office of Administrative Law to publish the NOPA, or the Notice of Proposed Amendment. And we anticipate for the intergenerational transfer exclusion rule that would be at the April meeting. And then for the base year value transfer rule, that would be at the May board meeting. The second time we would bring the rule back to the board would be for adoption after a public hearing. And we would anticipate for the first rule that would be in July, and for the second rule that it would be in August. And given all of the various considerations, such as time, transparency, and public involvement, we believe that this is the best time frame to follow. And I'm happy to answer any questions that you may have.
Thank you, Mr. Moon. Once again, I just wanted to really I'm looking forward to this rules resolving some of our critical issues that are concerning to the taxpayer as quickly as possible. And I am very grateful again to our Senators Hertzberg, Allen, and McGuire for including this emergency rulemaking authority for Prop 19 for the BOE in this bill, SB 539. But I have, and you kind of touched on it in your remarks here. One, I have a question, clarify how long a child transferee or their sibling must occupy the home in order to keep this exclusion.
Yeah, so both SB 539 and the rules require that the exclusion will last as long as an eligible transferee keeps the real property as their principal residence, and that is in SB 539. It will also be stated again in the rule.
Now, for example, I know we've heard this from some testimonies. If there's, let's say, 3 children, for example, and one leaves, how much time could lapse before another one could move in and claim it as their principal resident?
They would have the same 1 year that the original eligible transferee who moved in first had. And again, that would be made clear in the rule.
And then on the, okay, well, that's, what about, can we clarify the method, timing, and impact of Prop 19, the requirement for assessors to adjust any amount over $1 million each year based on the percentage change in the California Housing Price Index?
Yes, there is planned to be a provision in the rule that will cover that, and what will be required is that that's done beginning, I believe, in 2023, and then every 2 years after that, the board will look at that index and then publish, I'm assuming via the form of an LTA, what that adjustment will be.
Thank you. Are there any questions? Oh, I see a couple hands now. Let me start with Ms. Stowers and then Member Gaines. Go ahead, Ms. Stowers.
Oh, get to go first, thank you.
Your hand was up first.
Okay, let's start with SB 539 and then looking at the agenda. Mr. Moore, you said that you guys would do a dual track. You go with the regular rulemaking and you go with the emergency rulemaking. And then if SB 539 is enacted, you'll come back to the board to move forward with the emergency rules. So I have, when I look at SB 539, I'm not really clear if emergency rulemaking includes both intergenerational transfer and base year transfer, or just intergenerational transfers?
Well, what I can say is that the emergency rulemaking authority is in the part of the bill that's section 2, which is 63.2, which is the intergenerational transfers. But the language of the authorization says that we have authority to implement section 2.1 of Proposition 19, which is both base year value and intergenerational transfer.
Thank you for that clarification. That's what I thought, but I wanted to have you say it. I also want to talk about the regular rulemaking process and then the emergency rulemaking process. Let's start with regular. Again, let me say first, let me thank again the senators for moving this bill forward, 539, because it's extremely important for everyone. But I also want to acknowledge that I've been getting some phone calls and people are indicating that the BOE, for the BOE to take action on the regular rulemaking process to implement Prop 19 could be viewed as the BOE attempting to expand its authority or interfere with the legislative process. So, Mr. Moon, if you don't mind, or if Mr. Najo is there, can someone kind of give us an overview on why we are considering regular rulemaking process and what is our obligation and legal authority? And that's my first question regarding rulemaking. And then I do have a second question.
Okay, and hi, this is Henry Nancho, Chief Counsel. Mr. Moon, I can go ahead and take this, and then you can add in if I missed anything, if that's all right.
Certainly.
Okay. Thank you. So, as this board has discussed over the last several months, the Proposition 19, which was duly passed by the voters in November of 2020, left a lot of details ambiguous or without clarity. As the board knows, the Board of Equalization has an obligation to make sure that property tax rules are applied consistently and in a fair manner across the 58 counties of California. In this particular case, in an effort to provide guidance to the 58 assessors, especially on the intergenerational transfer issue, which became effective, Proposition 19 rules became effective on February 16th. It is our, basically in conjunction with working with the California Assessors Association, an attempt to provide that guidance which will help them do their work consistently. In regards to your comment about overreaching, on the part of BOE. The legal department is very sensitive to that. So what we are doing is we are strictly looking to the intent and the text of Proposition 19 and only making those rules which there is some basis on in both Proposition 19, either in the text or in some of the intent language. However, that being said, there are a number of issues that are still unclear, which we do not have that kind of basis or guidance on, which remains to be in the purview of the legislature.
Okay.
Does that answer your question, Deputy
I do
Controller
believe
Scout?
so, and you did kind of stepped over. You must have read my mind on an overreaching. That was my follow-up question. So I appreciate that.
Well, you mentioned that in your comments, ma'am.
Oh, did I? Okay, I have so much on my brain overload. Because I was going to thank you for that, because I've been around a couple of times with some, not necessarily BOE 2.0, but BOE 1.0, and another agency where they've had rulemaking regulations, and it was determined to be an overreach and rules determined to be invalid. So I'm happy to hear that you guys are sensitive to that and making sure that what you do in rulemaking is within the limits of Prop 19. And of course, if SB 539 is enacted and there's additional provisions within the law, I'm sure our rulemaking will follow it. So that kind of answered my question. Go ahead.
No, I said absolutely. We are very mindful and are taking great lengths to be consistent with the language that exists.
Thank you. Mr. Moon, did you want to add anything else to regular rulemaking?
Yeah, I mean, I guess the only thing I would add is that we are always sensitive to potential overreach on our part, and we are sensitive to the way that the government's set up in terms of the separation of the powers. The legislature is there to enact legislation, and we are to interpret that legislation. And so I guess what I would say specifically with respect to our thinking on Prop 19 is that SB 539 has been introduced. And I don't think there's anything that we've been thinking or that we would put in the regulations that hasn't been, I guess, blessed or confirmed by the legislature in SB 539. So I'm not sure. I don't think there's any overreach on our part.
Okay, great. Thank you. And Mr. Moon, you touched a little bit on the emergency rulemaking as it relates to SB 539. And I've also been a little bit of getting calls on emergency rulemaking, people acknowledging that SB 539 has a provision for emergency rulemaking, but they're also asking about the BOE's authority to do emergency rulemaking on its own if SB 539 is not enacted, or just to fast track everything. So I was wondering, for the record, if someone can give us a high level overview on the difference, what it would mean to have emergency rulemaking based on a board declared emergency. That's kind of general question. And then a second question to that is, what the board must establish in order to have emergency rulemaking if we don't have legislation? Any pitfalls that we come across for emergency rulemaking? And I have a couple more questions, and I'll wait till you guys can answer the first three.
Okay. Thank you, Deputy Controller Stowers. Mr. Moon, if it's all right with you, I'll try to take first shot at it and you can weigh in. Again, this is Chief Counsel Henry Nanjo. With regards to emergency rulemaking, all state agencies have the authority to do emergency rulemaking under Government Code Section 11342.545. However, that's only if an emergency exists that is a situation that, quote, calls for immediate action to avoid serious harm to the public peace, health, safety, or general welfare. Under this section, to justify the adoption of emergency regulations, the BOE must present specific facts supported by, quote, substantial evidence demonstrating the existence of an emergency and the need for immediate adoption of the proposed regulation to avoid such serious harm. As much as Proposition 19, judging from some of our public commenters, may be a major issue and cause serious harm to individuals in certain situations. It's a fairly high bar because BOE's jurisdiction is primarily related to taxation, for it to cause, quote, serious harm to the public peace, health, safety, or general welfare. So thus, in that respect, I would believe that it would be difficult for us to meet that standards. The risks are that if we do make an emergency regulatory package, that again, the board makes the finding that there is substantial evidence demonstrating the existence of serious harm to public peace, health, safety, or the general welfare, then that would be examined by the Office of Administrative Law, OAL, and if they do not concur with the board's finding that such emergency conditions are justified, the emergency regulations would then not be approved and the regulatory package thrown out. Because emergency regulations always affect the rights of the public in a shifting landscape, it's generally preferable for the board to act under clear authority, i.e. the legislative authority, so there's no question or possibility that our regulatory package can be thrown out. As you can imagine, for us to try to do emergency regulations that the assessors will try to follow and then have them thrown out will cause even more confusion to an already unclear situation. Deputy Controller Stowers, did I answer your questions or did I miss something?
I think you answered my question, sir. I appreciate that response.
Sure, and then Mr. Moon, did you have anything to add that I may have missed?
No, nothing to add.
Okay, then this is my final question, and I turn the mic over to someone else. I know that BOE recently completed rulemaking with respect to certificate aircraft, and we did do that under emergency rulemaking, but it was deemed emergency under RTC section 1157. And a similar agency, Secure Choice, did the same thing under Government Code section 100048. But again, it was deemed emergency by the legislator. I'm just curious, are any of you guys aware that a state agency did declare an emergency? And if so, did the Office of Administrative Law accept it? Just in your practice, if you have any insight on that.
Sure. This is Henry Nancho, Chief Counsel again. I have a vague recollection that there may have been a state agency that declared an emergency under either the wildfire situation or the flooding situation or something like that. That may have been through an emergency declaration, but I recall that those instances, if they occurred, were far and few between. In the vast majority of emergency situations, they are declared by the legislature.
Right.
Mr. Moon, are you aware of anything?
Well, I do know that there are some cases where emergency regulations have been challenged and they've been upheld. And the one that I remember kind of off the top of my head is emergency regulations. I believe it was either by Health and Human Services or Housing. And the reason why they declared an emergency regulation there was because they needed to conform some of their practices to federal law. And the court said that they upheld the agency's emergency declaration regarding that. The other thing I guess I can mention is that I'm not aware of any other time with regard to property tax rules where the board has done emergency regulations on its own. And this includes, you may recall, when the COVID pandemic had started, we had been talking about Revenue and Taxation Code Section 170, and the board had promulgated Rule 139 regarding a form of disaster relief after the 9/11 terrorist attacks. And the board at that time did not do those rules under emergency regulations. They did those under regular rulemaking as well.
Oh, that's helpful. That's helpful to know. Well, this is more, for me, educational, for the public who's listening, educational, not taking a position on emergency rules, but I just wanted to have the discussion since I keep getting the call. So I appreciate you guys responding to my questions. That's all I have for right now, Chair.
Thank you. Good questions. Member Gaines, I see your hand up still.
Yeah, great. Thank you, Chair Vasquez. And I just wanted to reiterate the family farm issue. And I'm just looking in our presentation here for Prop 19. And so it looks like we are clarifying family farm, and that's great that we're doing that, and that a family farm not necessarily be a primary residence. So we want to make sure that the farmland is included, and that being, land that's under cultivation, used for pasture, grazing, production of any agricultural commodity. And but there's a challenge here with family farm as it regards an appraisal unit. So, if I was, a farmer, I would want to make sure that my family farm was being protected. The intent in the language, I think, was not to create a sell-off of family farms. And yet, if we can't get clarification, we're going to run into a problem on this appraisal unit. It ought to be defined per APN versus any other fashion, because if you start combining parcel numbers together for a family farm, you're going to create tax consequences that will shut down some of those family farms across the state. I don't think that was ever the intent of Prop 19. The intent was to provide base year transfer, and then they tightened up in areas here in terms of the transfer of family home or a rental property. But I believe that the farming and ranching community was neutral on Prop 19 because they felt they weren't impacted. So that's an area that really needs to be zeroed in on and clarified in this legislation. So I think that is a challenge, and if it's not addressed, you're going to see a decline in family farms in California, and that was never the intent of the proposition. So just want to clarify that. Thank you.
Thank you. I see a hand up from our president from the assessors, Ernest Dronenberg. I don't know if he wants to comment on that or just has other questions.
No, I just wanted to tell Ted that, I'm sorry, Member Gaines, that that issue is not quiet. It is being very much debated. And when the skinny bill was put together, we were told it couldn't be controversial at all. So we looked at just the elements that we needed and just the elements that weren't controversial. The author of the skinny bill has talked about that issue, and he has said that, we're going to have we believe we'll have another bill, and we'll address the controversial pieces in that other bill, because that's not 100% agreed to by the assembly. So, and they've stated that, and so we've got to make sure that we don't give them something that's got a 1% controversial and they eliminate the whole bill. So that was specifically left out, but it's not a hidden issue. It's a big issue. The Farm Bureau is all over the issue and talking with the legislatures. But it wasn't an accident. And of course, the way you assess property, currently farms are based on a unitary value. It's the unit, not that a farm is appraised on currently. So in order to change that, we will have to have some kind of legislation that says a different method can be used. So I don't know if that helps Member Gaines to understand what's going on, but it should relieve your fears that this is something that nobody knows about. I mean, it's very hot.
Yeah, it's a big deal, and in terms of looking at an appraisal unit, that is that's a moving target for a farmer or rancher, because a ranch is in motion, right? So
you're talking to a 19-year member of the Farm Bureau who has heard about this.
We have a family ranch of walnuts, and over time we were either buying or selling a parcel here or there to whatever made sense for the ranch at that particular time. And so I think people need to understand that is an APN, an individual parcel number, should be treated as such individually. But it sounds like that's going to be addressed. So I'm hopeful to hear that. Thank you, Mr. Drunenberg. Appreciate it.
Chair Vasquez?
Yes, Vice Chair Schaefer, go ahead.
Back when I was in law school, I was in the tobacco farm business and I was in the corn farm business as a sharecropper in Southern Maryland. Today, farming is quite different. We think of it as the fields. Do we have a relationship with the cannabis industry? How does that fit into that?
I'm sorry, Mr. Schaefer, was that a question for me or Mr. Moon?
A question for Mr. Moon. As to how the cannabis industry relates to our family farm.
So we have not had any discussions or anyone from the cannabis industry reach out to us to see how it would affect them. What I can say, however, is that there's nothing specifically called out in Prop 19 in SB 539 or will be in our rules carving anything out or speaking specifically about cannabis. And so however they are organized now, so if it's a family farm that cultivates cannabis, the same rules that would apply to family farms would apply to that farm as well.
That's what I would expect. That's a good answer. Thank you, Mr. Moon.
Thank you. Seeing no other hands, I know we just had Assessor Jeff Prang from LA join us. I don't know if he had any questions or comments on this rulemaking process. Ms. Taylor, do we know if he's available?
Mr. Chairman, I'm on the line. So yes. I apologize. I was detained by other meetings, so I came in relatively late, so I didn't hear all the discussion, but I'm happy to answer any questions. I did hear some of the discussion that Assessors Association President Ernie Dronenberg stated. I'm happy to offer any additional information that you might need that Mr. Dronenberg didn't offer.
I think you were well represented. I'm opening it up in case you had a question, but if you're comfortable with your leadership, I think you should be okay.
We've laid out a careful and thoughtful plan trying to get to the finish line, which is creating an implementation plan for Prop 19 that will make it easy for assessors and the Board of Equalization to administer. As has probably been discussed, there's still a long road to get there. We're not necessarily confident that we're going to get everything that we need to administer it appropriately. I know assessors are really looking to the Board of Equalization for leadership. We're all going to have to stretch to provide property owners in California the guidance that they need, but absent a comprehensive legislative package, some of that guidance is going to be missing, and that will create some amount of confusion, if not chaos, in the in the system until such legislation is done. That concerns me a great deal because I know, like any other public officials, especially those of us who have to run for office, we don't want to be in a position to tell the public that we don't know the answers. But there is, while we still have time to work on this legislation, there is a real risk that we may not have all the answers, and that might end up being our answer, that we simply don't know the answers to a lot of questions taxpayers will have.
No, that's understood. And it's my understanding that if we move forward with the skinny bill with hopefully no amendments, it'll get through. And I'm hearing that there's going to be a strong, very strong opportunity for us to come back with a second bill that hopefully will include everything that I know you gave a list to us, and your assessors have really thought through everything that you need that is just basically administratively. We're hoping that we can include all of that and get it all approved in a timely manner to assist you folks.
So I am, I have a couple of different thoughts on this one. So one, as you know, we developed a comprehensive package to interpret Proposition 19, and I would describe that package as ministerial. It was non-controversial. It was simply assessors and the BOE going through it line by line and trying to clarify those points of administration and law that we need in order to provide guidance and direction to the public. There are elements, there's other stakeholders, the realtors, the Farm Bureau, the firefighters, that have certain interpretations that they would like to emphasize that may require a little bit more time to get to consensus, that are different than the ministerial definitions that we had proposed. Having the skinny bill move forward as Senate Bill 359 is a good first step, but I can say unequivocally it is not enough. It represents just maybe 10 or 20% of what we need to administer Proposition 19. So what we're hearing that they want to move that forward with no amendments does make me nervous, because at the moment we have a legislative vehicle to fix some of these deficiencies. We don't know that we're going to have a legislative vehicle to deal with the other 80 or 90% of Prop 19 that is not in 359. So if we could hear from legislative leadership that they recognize that the vast majority of Proposition 19 is not yet being addressed, and it has to be addressed this year, otherwise it's going to have significant impacts on the public. I'm going to be sitting on the edge of my seat until we get a little bit more direction and confidence that these issues are going to be on the radar screen this year.
No, that's well understood, and hopefully we'll have some good news on that shortly.
Thank you. Well, I do want to say, Mr. Chairman, that I very much appreciate the leadership, your leadership and that of your colleagues, as well as the board staff. It's been a really incredibly good partnership. We speak almost daily, and it's really demonstrated how much we can get done when we work together. Now we just need to create that next bridge to the legislature and the governor's office, and hopefully we'll get what we need to get this work done.
No, thank you. I mentioned it earlier in my opening remarks that I was really appreciative and thankful for you, and of course for the President, Dronenberg, for the participation and your efforts as well, because I know we tapped you as well as your staff these last 2-3 weeks, and I know we've had even meetings over the weekend, and really appreciated your time as well.
Thank you.
With that, if there's no other questions from any of the members, let me just check with Ms. Taylor. Is there any public comments on rulemaking process?
I will check with the AT&T moderator. AT&T moderator, can you please let us know if there is anyone on the line who would like to make a public comment regarding this matter? For the record, we request that the callers provide their name and limit their remarks to 3 minutes.
Thank you. If you wish to make a comment, please press 1 and then 0 at this time. And I currently have no comments in queue at this time.
Thank you. And Ms. Taylor, you said there was no written comments on this, correct?
Correct.
Thank you. With that, if you would please call our third item of the day.
The third item is K1D, Executive Director's Report, Operational Priorities and Projects, Report on the Status of Operational Priorities and Agency Projects, including requesting board authorization for further actions related to the legislative developments. The first sub-item is K1D, Proposition 19 Implementation. Ms. Renati will present an overview of the Implementation Action Plan.
Good morning, Chairman Vasquez and honorable members. My name is Lisa Renati, Chief Deputy Director. This morning, I will provide an overview of the BOE's Implementation and Action Plan for Proposition 19. For many decades, the Board of Equalization has been tasked with the implementation of legislation affecting our agency and tax programs. As an historic practice or methodology, the Board of Equalization has successfully utilized is to organize the implementation as a project, which allows an integrated and organized approach to ensure the full body of work is implemented. Using project management techniques, which focus on the delivery of desired outcomes, fixed timeframes, performance goals, and accountability, we will ensure a comprehensive implementation of Proposition 19 is achieved, which will also be cost-effective and efficient. As you know, the first component of Prop 19 regarding intergenerational transfer exclusions became operative just last week on February 16th. The provisions regarding base year value transfers will become operative on April 1st of this year. Accordingly, over the next few weeks, our existing Prop 19 project will be expanded with much more detail, including any necessary updates based on implementation legislation. The objective of the Prop 19 implementation project is to ensure our implementation is well organized so that we can anticipate issues and mitigate risks that would impede our ability to successfully implement this important legislation and fulfill our constitutional and statutory duties. Members, starting today, we will begin our first report on the Proposition 19 project as a team. As outlined in the public agenda notice, going forward, the team report presentations will remain in the same order throughout the project. Each team leader will provide updates on important milestones achieved and upcoming deliverables. Members, as you are well aware, the BOE's responsibilities and duties affected by Proposition 19 touch many facets of our agency. We are confident that our long-standing history of implementing legislation and the best practices learned through past successful project planning will serve us well. We are fully prepared to act on the necessary components of the project, and the subsequent reports by the agency's leaders today will provide you with information on the project's implementation actions achieved to date. As the project continues, the team and I will provide monthly updates of our progress to ensure you are informed, to allow public participation, and to present material that requires your action and/or approval. Most of the information and updates will be presented under Item K, Other Administrative Matters. But members, for the near future, we will also keep this item under M, Public Policy Hearings, to allow important discussions regarding any legislative matters. Members, unless you have any questions for me, I would like to turn to each team leader so they can provide you with information on their department's implementation actions, including updates on guidance provided. And seeing as there's no questions. Oh,
no, go ahead. Go ahead. I'm sorry. Go ahead, Ms. Wright.
Unless there's any questions you had, Mr. Chairman.
I'll wait to finish. Go ahead.
I'm sorry, it's so hard with the delay. So the first report will be provided by Chief of County Assessed Properties, Ms. Patty Lumsden, who will provide a report on the Property Tax Department's implementation actions, including updates on guidance.
Good morning, Chair Vasquez, honorable board members. My name is Patty Lumsden, and I'm the Chief of the County Assessed Properties Division here at the State Board of Equalization. And today I'm going to report to you on the Property Tax Department's Proposition 19 implementation actions and guidance updates that have been put in place to date. As part of the Property Tax Department's Prop 19 implementation plan, the following items have been completed. So far, we have issued letter to assessors number 2020-061 to announce the passing of Proposition 19 and to provide some general information, and this has been posted on our website. We have also issued letter to assessors number 2021-007, which contained our 7 newly created and 4 existing forms that we put out to assist assessors in collecting necessary information to implement Prop 19 for both intergenerational transfers and base year value transfers. We also have issued letter to assessors number 2021-008, which provides guidance on Proposition 19 intergenerational transfers. And this is done through a total of 44 questions and answers. And we have also created on our website and posted on our website some frequently asked questions and that relate to both base year value transfers and intergenerational transfers for Proposition 19. We also have on our website created comparison charts that reflect the effects of Proposition 19. And then plus in addition to that, of course, is a Chief Counsel memo that's posted to our website, as well as a Proposition 19 fact sheet. So we have some next steps that we plan on following to stay up on our implementation plan. And that is we are now working on providing further guidance for the base year value transfer portion of Prop 19, and we will be issuing another questions and answers LTA similar to the one we issued for the intergenerational transfers. We will be continuing to update our website as new information is available, and we will continue to work with our legal department on the promulgation of regulations to assist in the implementation of Prop 19, and we continue to track legislation relating to Prop 19, such as Senate Bill 539. And we plan on reviewing and updating Assessor's Handbook sections, letters to assessors, county assessors only letters, annotations, and other documents or publications as needed. As we have discussed in previous meetings, there will be some of these sections that will remain in effect for some time, such as some of the Proposition 58 parent-child transfers will still be in effect for a while, and so we'll have to evaluate our documents to see what updates we need to make. We also are working with our TSD section to update and revise our current database in order to track the number of base year value transfers throughout the state for persons over 55 and persons that are severely disabled in order to continue our clearinghouse functions at the BOE. And this is due to our current database has the ability to follow one-time transfers, but with the Proposition 19, we will now be needing to update it so it can track 3-time transfers under the new provisions. And of course, we will still continue to track the $1 million exclusion under the prior Proposition 58 provisions until that no longer is necessary. And we will continue to issue guidance and create and amend forms as the need arises for both intergenerational transfer exclusions as well as base year value transfers as they relate to Proposition 19. This will be an ongoing effort, and we will continue to work with our legal department and the California Assessors Association in order to address those issues as they come up during this process. And that concludes my report, and I'm available to answer your questions.
Thank you. Ms. Renati, did we have Mr. Moon also making a presentation on this, or are we going to wait?
Thank you, Chairman. I believe Mr. Moon was going to add or assist Ms. Lumsden as needed. So if you have any questions that she needs help with, he'll jump in. But for now, he'll go on to the next comment when you're ready.
All right. Seeing no hands, I just had a quick question, and I don't know if it's more addressed to Mr. Moon or Ms. Lumsden, but it's you know, that we're still getting complaints from taxpayers who tried to transfer property under the old parent-child exclusion and are being told they are too late if the deed wasn't recorded by February 15th. My staff explains that an unrecorded deed is acceptable, and 2, that the signature on it February 16th is acceptable since the 15th was a holiday, and that they addressed this by the Chief Counsel's memo, the LTA number 2021/08, and the FAQs on our website. But would you mind stating, for the sake of the listening public, where they can most easily find the clear, simple statement to this effect on Prop 19 on our webpage?
Yes, Chairman. So as you mentioned, that particular issue has been brought up, and we do also still get questions in regards to it. We did specifically put that question and answer in our LTA, as you mentioned, under 2021-008, and it is question number 4. And also, as you also mentioned, is we also have it on our website under our frequently asked questions, and it's under the parent-child and grandparent-grandchild section of that under question number 8. So they are out, that information is out there, as you pointed out, in our website. So if there's, another spot that you maybe think would be more accessible to the public, and we're definitely open and willing to get further input on that. But currently that's where that information is.
Thank you. So for the viewing public and hopefully folks that are listening, so you said it's on page 8, I believe?
It's question number 8 of our frequently asked questions. Yeah, we have there's a tab under the Proposition 19. If they click on Proposition 19 on our website, there's a tab for frequently asked questions, and it's under that section in there, and there's a part that deals with parent-child and grandparent-grandchild questions, and it's question number 8.
Thank you.
You're welcome.
And going back just a minute here for Ms. Renati, when in your opening remarks, I just wanted to, especially based on your overview, it was clear that you have various timeframes and targeted completion dates associated with each part. I just want to affirm that I'm very supportive of that and want to emphasize how important it is for the taxpayers in my district and myself to have received sound information that we can rely on in a timelines and the timelines established. So I just wanted to make that statement and appreciate that.
Thank you, Chairman. This is Lisa Renati.
With that, was there, you said Mr. Moon was just there for reference, right? He's not making a presentation then.
Correct, Chairman. Mr. Moon will be available in the next report regarding the legal department.
Okay. Then I know you were going through all the different bullets here. Did we leave one out or are we finished on your end?
No, if you will allow, I can introduce the next report.
I want to make a comment on.
Vice Chair Schaefer, did you have a question?
I think it's not really relevant right at the moment. We moved on.
Oh, okay. Well, I just thought maybe the board's interested if we have any.
Just a reminder, if you're not speaking future.
We don't call it cannabis. It's hemp in my district.
Okay, thank you. I'm sorry, Mr. Renati, go ahead.
Thank you, Chairman. Again, this is Lisa Renati, Chief Deputy Director. The next report will be provided by Chief Legal Counsel Henry Nanjo and Tax Counsel Richard Moon, who will provide a report on the legal department's implementation actions and the next steps.
Thank you, Ms. Renati. Chairman Vasquez, honorable members of the board, this is Henry Nanjo, Chief Counsel again. I'm actually going to let Mr. Moon take a break. So if there's questions for him, of course, he's available to answer, but I'll cover this brief report on the legal department's implementation actions. As is the case with most elements of BOE, the legal department has had a serious increase in the number of inquiries we've gotten from taxpayers and other professionals regarding Proposition 19 questions. In an effort to provide timely service and respond to these inquiries, the legal department's been reorganized a little bit. I've actually designated a senior attorney as a lead for Proposition 19 issues. That attorney, Ms. Sonia Yim, is also working with the Property Tax Department and the TRA, Taxpayer Rights Advocates Office, to ensure that we have consistent answers and we get appropriate information as quickly as possible to those who are asking for our assistance. In addition, the legal department has been supporting the Property Tax Department and Taxpayer Rights Advocates Department in reviewing materials and ensuring that we get appropriate and legally correct information up on our websites and through materials that have been sent out. We also are working hand in hand with the Property Tax Department with regards to making sure that common inquiries and or questions are answered. I can't speak enough on behalf of the Property Tax Department and the TRA for the efforts they're doing in order to get information to taxpayers. Finally, the major effort of the legal department has been working with the California Assessors Association and in conjunction with them on both any efforts to get legislation and discuss issues, as well as the yeoman's regulatory work that Mr. Moon has already reported on and given you pretty much a full report on. But that's all, again, we're dual tracking two different regulations, one on the intergenerational transfers and the other one on the base year values in an effort to get some clarity out to the assessors. And that is primarily the report on the legal department's implementation actions. Mr. Moon, did you have anything to add?
No, nothing to add.
Thank you. And back to you, Ms. Renati.
The next report will be provided by the Board of Equalization's Chief Communication Officer, Peter Kim. He will provide a report on the Communication Office's planned Prop 19 implementation efforts.
Thank you, Ms. Renati. Chairman Vasquez and honorable members, this is Peter Kim, Chief Communications Officer. Members, today I will provide a brief report on the Communications Office's efforts in operationalizing and implementing Proposition 19. As you know, the board approved the Communications Plan on Education and Outreach in January. I am closely collaborating with our Taxpayers' Rights Advocate, Lisa Thompson, to explore additional ways in educating and reaching out to taxpayers. The Proposition 19 webpage is continually being updated and enhanced to provide the latest information in real time for taxpayers. As of this morning, a minor refresh of the design of the BOE website went live. We've also added additional questions and answers on the frequently asked questions page and posted the link to the latest letter to assessors with a series of 44 questions and answers on the intergenerational transfer exclusion provisions related to Proposition 19. While it is guidance to county assessors, it can also serve and be helpful to taxpayers in better understanding Proposition 19. We have also begun to post a notice on existing web pages on the BOE website that have Proposition 58 and 193 information to remind taxpayers that they are no longer operative for transfers on or after February 16th. Since the Proposition 19 webpage went live on November 10th, soon after the November 2020 general election, and up until yesterday, there have been almost 100,000 unique external visits, reflecting that the BOE website is an essential communications tool in sharing Proposition 19 information. Finally, our social media channels such as Facebook, Twitter, and Instagram are being utilized to expand our audience and direct followers to the BOE website for the latest updates. This concludes my report, and I'm available to answer any questions the board may have. Thank you.
Thank you, Mr. Kim. I just have one quick question, if nobody else has one, and that's, the assessors and board members have held virtual webinars on Prop 19, and I assume we will plan to continue more how-to webinars, especially to help taxpayers understand and comply with Prop 19. Could you tell me what's the best way for the public to keep informed about these events?
Mr. Chairman, thank you for that question. As I've committed before, our webpage is really to serve as a repository of information. I will look into seeing if it's feasible to add a calendar of events tab on the Prop 19 webpage to possibly list events hosted by either board member offices or county assessors where the board is a partner when advance notice is provided. So I'll definitely take a look into that and follow up with your office and the board. Thank you.
Thank you. I think there's a great need for some personal how-to communication with taxpayers, and that would be really helpful. I see a hand for Member Gaines. Go ahead, Member Gaines.
Thank you, Chair Vasquez. I was just wondering, Mr. Kim, if you could maybe give me a little better sense in terms of constituent contact at the website. And I'm just trying to get a read on kind of what that algorithm looks like in terms of the number of people responding. And are you seeing it diminishing as we get farther away from the Prop 19 deadline of February 16th, or is that interest just continuing to grow? I don't know if you've got breakdowns on a weekly basis or daily basis or something of that nature that kind of give me a little better indication of the demand there.
Yes, Board Member Gaines, thank you for that question. I may need some assistance from our property tax department because they are the lead in terms of fielding questions from taxpayers, but I do know that generally speaking, that all the questions we do receive, we make sure and take inventory of what types of questions they have, just so that we make sure that our webpage and our website is responsive to their needs. I don't know if someone from the property tax department could provide that information to you now, but we could definitely circle back with the board if we can't do it at this moment.
How about just in a more general sense, do you know like how many hits we're getting on the website in a kind of a looking back on a weekly basis?
Yeah, I don't have that specific data in front of me right now, but I do know that as I reported, we almost have almost 100,000 unique external visits since the webpage went live. And so it is a reflection of just the demand that taxpayers and other folks are looking for. And so hopefully we continue to serve as that repository of information for taxpayers.
Sure. Okay. And I think my recollection is, weren't we around 90,000 on February 11th? I'm trying to remember the last time you gave us a report. Was that the 11th or?
Yes, sir. So the data that I provided to the board was as of February 16th. So it's been maybe a little over a week. And so therefore it's gone up to almost 100,000. I think we're like 16 visits short of being 100,000. So that is just sort of a snapshot of just the traffic from that period. Yeah.
All right. Wonderful. That's helpful. Thank you.
Thank you.
Thank you. With that, seeing no other hands or comments, let me have Ms. Renati, if you would please introduce Ms. Thompson, who will report on the 5th bulleted sub-item, the Taxpayers' Rights Advocate Office implementation actions.
Thank you, Chairman. This is Lisa Renati, Chief Deputy Director. As you stated, the next report will be provided by Lisa Thompson. She's our Taxpayers' Rights Advocate, and she will provide a report on the implementation actions to be completed by her office.
Good morning, honorable board members. My name is Lisa Thompson. I'm the agency's Taxpayer Rights Advocate, and I'm pleased to report to you on the Proposition 19 implementation and action plan for the Taxpayer Rights Advocate Office. The Taxpayer Rights Advocate Office is reviewing guidance issued by the Property Tax Department and board-prescribed forms adopted to ensure we are aware of all the comprehensive information issued by our agency to assist county assessors and taxpayers with the effects of Proposition 19. As soon as implementing legislation has been adopted for the provisions of Proposition 19, the Taxpayer Rights Advocate Office will begin revising existing information sheets on the parent-child and grandparent-grandchild transfer exclusion, as well as the base year value transfer for seniors and disabled persons. Because property transfers and home purchases will have occurred prior to the effective date of Proposition 19, it is important that we maintain information concerning transfers occurring before this time when Proposition 58 and 193 were still in place for family transfers, as well as under Proposition 60, 90, and 110 for seniors and disabled persons. We're considering how best to present this in conjunction with property transfers occurring after the effective dates of Proposition 19 for the various provisions. It is important to the Taxpayer Rights Advocate Office that taxpayers understand what laws apply to them and under what time frames. It is likely that we will have information sheet publications that address transfers occurring before and after a certain date. To ensure that taxpayers are aware there were changes made to the exclusion and base year value transfer provisions, the Taxpayer Rights Advocate Office worked with the Communications Officer, Mr. Peter Kim, as well as the Legal Department to place an important notice on the TRA Office's webpage under the Taxpayer Education area to notify taxpayers that as of certain dates, the provisions for the family transfer exclusion and base year value transfers were affected by the passage of Proposition 19. Specifically, that the parent-child and grandparent-child transfer exclusions added by Proposition 58 and 193 are repealed, and that Proposition 19 instituted new intergenerational transfer exclusion rules as of February 16, 2021, and also that Proposition 19 instituted new base year value transfer provisions for persons age 55 and over and disabled persons that become effective April 1st, 2021. The Taxpayer Rights Advocate Office will continue to work with the Communications Officer on education and outreach, which is the topic of the next agenda item. Unless there are any questions regarding the update for the Taxpayer Rights Advocate Office implementation plans, that concludes my update.
Thank you. Members, do we have any questions of Ms. Thompson? Seeing no hands, we will continue. Ms. Renati, I believe now you have, is it Ms. Thompson coming back again? I think she is.
Chairman, that's correct. The final report will be provided by Taxpayers' Rights Advocate Lisa Thompson, who will provide a report on implementation actions regarding education and outreach as regards Prop 19's implementation.
Ken, I'm Lisa Thompson, and I'm here to present information on the Proposition 19 implementation and action plan for education and outreach. At the February 11th, 2021 board meeting, the Communications Officer, Peter Kim, and I provided an update on the activities related to education and outreach. As part of my remarks, I explained that a fact sheet on Proposition 19 was created and posted to our website under the Additional Resources tab of our Proposition 19 page, which presented information on the base year value provisions for seniors and disabled persons that will become effective April 1st, and presents information on the parent-child and grandchild exclusion that became effective February 16, 2021. I also updated you on the creation of a PowerPoint presentation on Proposition 19 that could be used for speaking engagements by board members' offices and the standard PowerPoint presentation slides that were posted to our website. Peter Kim and I have been watching for implementing legislation for Proposition 19 so we can make any updates to the fact sheet and PowerPoint presentation as necessary. Peter Kim and I are also working closely together and collaborating on updates to Proposition 19 frequently asked questions on our website to ensure taxpayers are informed. Recently, a question was added to the website addressing how to apply for the homeowners or disabled veterans exemption and directing them to additional resources about those exemptions, since taxpayers applying for the parent-child and grandparent-grandchild exclusion are required under Proposition 19 to file for the homeowners or disabled veterans exemption within 1 year. As indicated previously, the Taxpayer Rights Advocate Office will revise its information sheets on the exclusion and base year value transfer topics affected by Proposition 19 and continue to draft information sheets on other topics to ensure taxpayers have information available to them in simple, non-technical terms. This concludes my update for the Education and Outreach Implementation Plan. I'm available if you have any questions.
Thank you. Members, do we have any questions or comments for Ms. Thompson? Member Gaines, go ahead.
Yeah, thank you, Chair Vasquez. I just want to thank Ms. Thompson and again, Mr. Kim for their efforts. That website is just so much better than it has been historically, and I think you know, if we could just continue to make sure that we're staying in touch with constituent needs and having that reflected through our website, it's a great means of communication to our constituents. So just want to thank them for their efforts and improving it so dramatically. Thanks.
Thank you. Look, Vice Chair Schaefer, I think had a hand
yes,
up.
Chair Vasquez, I'm just reading Ms. Thompson's report. It's out, I think, a little earlier this year, which I like. I notice under taxpayer service improvements on page 10, he features 6 counties that have made improvements in the services provided to the public. None of those counties are in my district. I wondered if my district ever does submit something for her evaluation. I assume she solicits all 58 districts, and some choose to respond and some, I guess, choose to not respond. Could she tell me something about her experience in dealing with District 4 assessors' offices?
Yes, so yesterday I provided an update on the Taxpayer Rights Advocate annual report, and that just as in addition to our educational component that I discussed with you today, what we do is we solicit input from assessors each year after the fiscal year in about August timeframe, and we send the request to all 58 counties. It's a one bulk email that asks for information on different customer service improvements that they have submitted during that particular fiscal year of the report that we're seeking information for, that we would like to incorporate into our annual report. So assessors determine whether they're going to submit information to incorporate, but even though a particular county might not be identified in the report, it doesn't mean that they are not providing customer service improvements or they've done improvements to their systems during that time frame. So,
So that
we
doesn't
have had
mean they,
historically.
yeah, Ms. Thompson, that doesn't mean that they've ignored you. They may have submitted or may not have submitted something, and in any event, it's not in the top 6 that you featured, which I have no problem with that.
Yeah, we submit, if someone submitted, if an assessor submitted information, we would incorporate it. Yes, so if it was submitted, it was incorporated. But, you know, in many respects, different assessors' offices, they may, place information on their own websites to indicate different, service improvements that they made.
Yeah, well, this morning I talked with Imperial County Assessor, and they have a growing hemp business, which is dealing with the fibers and making the clothes, and disputes they have with the Bureau of Reclamation to buy water, and they're making a lot of progress there to be able to better serve the hemp farmers in our district. And I would like a lot of this very positive stuff as soon as it's finalized to maybe get into your top 6. But, if they don't submit it, you can't know about it, okay?
Okay, well, thank you very much. But, yeah, and I'll reach out to the Imperial County Assessor separately, in addition to a group email, just to inquire that. But this would be, what's reflected in our report pertains to, assessment, property tax assessment. So if it was not in that area, the hemp area is just
sure.
Something
Well,
different than
Robert
property tax
Mendel.
matters, and it wouldn't be reflected in our report. But I will reach out to the assessor to ask that
Robert
question. Thank
Mendel,
you
the
so much.
assessor, has been there for many years and really knows the community. I've been down to a rodeo with him with my staff, and we feel that he's doing a great job. Thank you.
Thank you.
Thank you. Seeing no other comments, let me have Ms. Taylor, if you would please check. Do we have any written comments on this item before we go to the public?
Sir, we do not.
Let's go ahead and check with AT&T and see if there's any public comments on the Prop 19 Implementation Action Plan.
Thank you. AT&T moderator, can you please let us know if there is anyone on the line who would like to make a public comment regarding this matter? For the record, we request that callers provide their name and limit their remarks to 3 minutes.
Thank you. If you wish to make a comment, please press 1 and then 0 at this time. And we'll go to the line of Joseph. Please state your name followed by your comment.
Joseph Panino. My comment is that I have a memorandum dated January 8th, 2021 from Chief Counsel Nanjo. And it specifically states in there the implementation of the base transfer, base year value transfer. And it gives there's a question regarding it, and it's very clear at that point that the process does not have to take, that the process, there's an exemption for the April exemption, which basically means the transfer, just filling out a form. Any comments on that?
Is Mr. Nanjo on the line still?
Yes, I am, Chairman Vasquez. For the speaker, this is kind of what we were talking about earlier in the discussion. The Chief Counsel memo and guidance that we provide the assessors is just that, it's guidance. The individual assessors may or may not choose to follow it. So that's an issue to take for the speaker to take, or the caller to take up with their individual county assessor. And this also, as I mentioned earlier in the proceedings or hearing today, this is why we feel that it's necessary to do some of this by regulation. Thank you, Chairman Vasquez, members of the board.
Thank you. Ms. Taylor, do we have anybody else on the line?
We do not.
Thank you. And you know what? Can we also check if the assessors, I know we have a couple of the assessors, if they wish to comment or make any suggestions or questions on this item before we move on as well? Hearing and seeing none, I think we're okay. Ms. Taylor, before we move on to the next item, I just wanted to see if I can get you to go back. It just occurred to me that when we were discussing the rulemaking item under G on the agenda, we didn't make a motion supporting that rulemaking. And I was wondering if we can go back to that.
Sure, I can recall the item and then you can proceed.
Please.
We will return. We will return to G1, Chief Counsel Matters Rulemaking Overview of the Plan to Develop Guidance and Rulemaking that was presented by Mr. Moon.
Thank you. And I would just like to entertain a motion to see if we can get a motion to support that rulemaking that took place. And I see a hand up by Ms. Stowers. Go ahead, Ms. Stowers.
Thank you, Chairman Vasquez. I'm prepared to make the motion to authorize staff to move forward with the regular rulemaking process as described by Mr. Moon during the discussion under G1. The action should include the following 8 items and other steps as needed. Prepare property tax rules to address intergenerational transfer and base year transfer. Amend existing property tax rules as needed. If and when SB 539 is enacted, come back to the board for approval of the emergency rules related to intergenerational transfers and base year transfers. Complete the public comment period for intergenerational transfers by next week. Complete the public comment period for base years 1 to 2 weeks later. 6, come back to the board in April for approval to have the Office of Administrative Law publish a notice of proposed action for the intergenerational transfers, and come back to the board in May for the office to approve the notice of proposed action for base year transfer. And hopefully, number 8, the board to approve the intergenerational transfers in July, the property tax rules for that transfer, and then in August, approve the property tax rules for base year transfers.
Second.
That's been moved and second. Seeing no other comments or questions, Ms. Taylor, if you would please call the roll on that.
Chair Vasquez.
Aye.
Vice Chair Schaefer.
Aye.
Member Gaines.
Aye.
Member Cohen.
Aye.
Deputy Controller Stowers.
Aye.
So that's unanimous of those present. And with that, Ms. Taylor, if we could move on, I guess now we're on the 4th item.
Chairman Vasquez, this is Chief Counsel Henry Nanjo.
Yes,
on behalf of the legal department, we will try to comply as closely with that timeline as possible. But if I can ask the board members for some flexibility, we are kind of dependent on working with the Office of Administrative Law, and sometimes things don't go exactly as we plan. So if we can use that as general authority and guidance for those timelines, please understand that we may need to modify that as necessary.
Chairman Vasquez.
I'm sorry,
going
Ms. Towers, go ahead.
I wanted to adjust my motion to understand that they will have to adjust the timelines as they are dependent on other agencies. So it's just as long as they are moving forward, as Mr. Nanjo commented.
Second.
Ms. Taylor, I guess we need to take another roll call on that amendment then?
Certainly. Chairman Vasquez,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines,
Aye. Aye.
Member Cohen,
Aye.
Deputy Controller Stowers.
Aye.
Thank you, members. So that's approved unanimously. And with that, Ms. Taylor, if we could move on to the fourth item.
The next item is K4, Legislative Research and Statistic Division Chief's Report. The first sub-item is K4B, Proposed Legislation Related to the Implementation of Proposition 19, presented by Ms. Fleming.
Ms. Fleming, are you available to tell us about the proposed Prop 19 implementation legislation, SB 539, and the next steps in the process and the recommended action for the board?
Yes, thank you, Chairman Vasquez and honorable members. Brenda Fleming, Executive Director. Members, as you've heard today, with some really good discussion, and we certainly hope the information provided not only provides updates on what's going on with Senate Bill 539, but the importance of this legislation and the need to clarify some of those things that are ambiguous. So we really appreciate the discussion, and members, we also appreciate the support to proceed with the rulemaking process. Members, based upon today's discussion, staff recommends that as we prepare for the next steps, which would be the Legislative Policy Committee hearings, that we have the board submit a letter and board approval to submit a letter of support for Senate Bill 539 to the legislature. Based upon some conversations that we're having with the Policy Committee in both houses, it looks like we need a letter of support by Friday, February 26th, in anticipation of some possible hearings coming up soon. So if we could, members, I would appreciate the board's approval to proceed with a letter of support for Senate Bill 539.
Thank you. Members, do we have any questions or comments of Ms. Fleming's and her recommendation?
Do we need a motion?
I believe so.
So moved. This is Member Gaines. Thank you.
Member Vice Chair Schaefer, I second it.
It's been moved in second. And actually, yeah. Oh, I see a hand by Ms. Stowers. Go ahead, Ms. Stowers.
I'm in support of the motion. I just want clarification. Board approval of SB 539. Will this letter be going out on the chair's letterhead? Or will it be going out
on? That would be the board's
BOE?
pleasure.
Well, how do the members feel about that? I'm good either way.
If you need to do it quickly, I just soon have the chair do it. So, but I'm flexible, whatever the board desires.
I would like to see the chair do it as well.
You want to do that?
Yes, the chair.
Okay, we'll just do it through the chair because it'll probably be the fastest. So we have a
thank you, members.
Second, and I see I see a hand up by Ms. Dronenberg. Go ahead, Ernie.
Yeah, I'm issuing a support letter on my stationery as president of CAA, and it'll be there too by Friday. So that's generally how the CAA operates. The president issues the letter.
Appreciate that.
It's okay. I guess that was time.
Ms. Fleming, that's all. Is that all? That's all you need at this point, right?
Yes, sir. Thank you, members, for the support. Thank you for preparing to send and submit a letter of support on SB 539. Much appreciated.
Let me get Ms. Taylor to call roll on that.
Chairman Vasquez,
Aye.
Vice Chair Schaefer,
Aye.
Member Gaines,
Aye.
Member Cohen,
Aye.
Deputy Controller Stowers.
Aye.
So that's unanimous of all those present. Ms. Fleming, was there anything else on your report, or was that it?
Chairman and members, that concludes my report.
Thank you. And moving forward, if there's no other comments or questions, let me get Ms. Taylor to call the next item.
The final item would be in public comment on matters not on the agenda. We did call this yesterday, but we can call it again if you wish.
Well, let me ask Mr. Nadja, do we have to, or are we, I just want to make sure we're in compliance here.
No, we are in compliance. There is no need to call it because it was called yesterday.
So Ms. Taylor, it sounds like
your call, Chair.
If the members are comfortable, I would just move on. Ms. Taylor, there's no other, and I seen heads nodding, so I think we're good. I just want to make sure legally we're doing this thing right. And Ms. Taylor, it sounds like that's the end of today. Is that correct?
That is correct.
Let me, in closing, and then I'll turn it over and see if there's any other members that want to have any comments. I would just like to thank Ms. Fleming, Mr. Moon, Ms. Renati, and the entire BOE staff and the assessors, team members, for the tremendous work they did getting this legislation into the form it is today, as well as the efforts that developed, that published the detailed letters to the assessors, a dozen important forms, fact sheets, and other information required for the effective Prop 19 implementation. It was a Herculean task, and in very short time. In recognition of Black History Month, I'd like to adjourn this meeting in honor of the civil rights leaders, past and present, and the countless Americans from all walks of life who continue to work for promoting awareness and positive change to help create fairness and equity for all Black Americans. And with that, let me just see if there's anybody else that has any other closing remarks before we officially adjourn this meeting. Seeing no other hands or comments, we stand adjourned. Oh, I'm sorry. I see a hand, Member Gaines. Go ahead.
I'm sorry, I didn't get my hand up fast enough, but
Not a problem. Go ahead.
I just want to thank you for your leadership effort, because it's been a lot of work to address Prop 19, and the board as a whole, I think, has done well, and certainly the staff that put in the long hours. But Tony, you're the head, you're our chair, and thank you for that leadership.
No, thank you all, and thank you for your patience. I know at one point it was really, we were all kind of nervous because we just couldn't get anybody to put together this bill for us. And like I said, I just want to thank, obviously, the leadership, Senator Hertzberg and my Senator, Ben Allen, as well as Senator McGuire, for stepping up and being co-authors, because hopefully with that combination, we can get this thing through in a very timely manner. Because I know in listening to the assessors, they're really, really in a pinch. You know, they need to know ASAP so they can begin to implement Prop 19. But thank you all. And I see a hand up by my Vice Chair Schaefer. Go ahead.
Chair Vasquez, I just want to second Member Gaines' laudatory remarks, and especially thank Senator Bob Hertzberg for all he's done. He is the most powerful, second most powerful senator in the state. He's given his full time to making all this happen, and he should know that we all appreciate him very much.
Thank you. And with that, members, we will go ahead and officially adjourn this meeting at, I have 12:02. And our next meeting is scheduled for March 23rd. at 10 a.m. Unless we have any other comments, and thank you again to the assessors. I see Mr. Dronenberg still with us, and I believe Jeff Prang is still with us. Thank you for your time. I know we held you over for most of yesterday and part today as well. Thank you for your participation and your patience as well. With that, we're officially adjourned, and we'll see you all on March 22nd. Thank you. Enjoy your rest of your day.
Take care.